Now, in today's video, we're going to be talking about the Supreme Court decision in Cargill v. Garland. This is the bump stock case. And we got a win. Justice Thomas issued the majority opinion, essentially overturning the ATF and saying that bump stocks do not convert a semi-automatic rifle into a machine gun. Now, it's a victory. There's no question about that. If we look at the metrics of whether or not a particular Supreme Court decision advances freedom or restricts freedom, this is by definition an advance, or probably more accurately described, it's a push back on a restriction on freedom. Now, that being said, I was candidly hoping for more in this decision. It's somewhat limited. And I'll explain my rationale in that and some of the problems, ironically enough, that could potentially stem from this decision. It's a victory, but it's a victory with some dubious undertones attached to it. So first off, what is the bump stock? Well, many of you that are watching this video are already well aware of what a bump stock is. A bump stock is nothing more than a device that assists a shooter in engaging in what we call bump firing. Now, you don't need a bump stock in order to increase the rate of fire on a semi-automatic firearm, but it assists a shooter in increasing the rate on a semi-automatic firearm. Now, this first came really into play after the horrific events that had taken place in Las Vegas. The shooter there had equipped a majority of his firearms, at least several of them, with bump stocks. And it does legitimately, the use of bump firing does increase the rate of firing. Essentially, you're holding the trigger to the rear and forcing through the recoil of the firearm a resetting of the trigger. This allows the firearm to essentially work at a faster rate. Another possibility of increasing your rate of fire is to simply move your trigger faster. But the bump firing methodology has been around for years. Now, these devices, these bump stocks, essentially are designed to assist a shooter with performing that bump firing technique. And there have been several ATF decisions that said a bump stock does not convert a semi-automatic firearm into a machine gun, which would be federally regulated. And as a result of that, one could argue that there were many people that elected to acquire bump stocks. Well, after Las Vegas, President Trump essentially ordered his ATF to reclassify bump stocks as devices that have in fact converted a semi-automatic firearm into a machine gun. And they did an about face, and they immediately put out a final rule saying, yep, they are in fact machine guns. This was challenged, and it's made its way to the Supreme Court, where the Supreme Court has rejected the ATF's analysis. They said, no, it does not. Now, what we were hoping for was that the Supreme Court would be using this case for essentially two purposes. Of course, those that own bump stocks are going to see this as a victory, and, candidly it is. But we were hoping that they would use this as what we call a vehicle case. Oftentimes, the Supreme Court will use a particular gravamen of the issue and then expand on that. New York State Rifle and Pistol Association v. Bruin is a classic example of this. That case was literally limited to the question of whether or not the Second Amendment exists outside the home. That was it. And yet it expanded to now include our new constitutional test that we use as history, text, and firearms regulatory traditions. So just because a case is limited to one specific triable issue of fact does not necessarily mean that the court would use it in a more expansive methodology to give us sort of how to interpret future cases, or alternatively what the outer limits of the Second Amendment are. In this case, the Second Amendment never even comes into play. There is no Bruin analysis that's done in this. It's exclusively based on whether or not the ATF exceeded their regulatory authority. Now, that in and of itself is good because it's putting that pressure on the idea that regulations should be developed by Congress. They should not be developed by a regulatory agency. And in fact, we are going to be getting another decision, hopefully within the next couple of weeks, that will further, hopefully, opine on the idea that laws and regulations should come from a legislative body rather than an executive one. In any event, Justice Thomas goes through a fairly exhaustive analysis on what is actually occurring during the firing sequence when someone is using a bump stock, and comes to the ultimate conclusion that it does not convert a semi-automatic firearm into a machine gun. For those of us that look at hardware, this is sort of a statement of the obvious. But for those that are outside the Second Amendment community, they may not necessarily know what a bump stock is or the functionality of a bump stock. So, okay, fair enough. He goes through and he explains all these things. Of course, the dissent, is totally at odds. They think that these things should be simply limited. Now, here's my problem. I really was hoping that they would use Cargill to, in fact, slap down a lot of what we call the hardware regulations that have started to manifest in other jurisdictions. So whenever we look at Second Amendment related cases, they essentially fall into two categories. They're either going to be what we call hardware-based restrictions, or they're going to be behavioral-based restrictions. And sometimes something might start out as a hardware-based restriction and then convert later on into a behavioral-based restriction. That is what I'm concerned about happening here, to be quite candid with you. Hey guys, I'm going to pause this video for just a moment. USCCA, which is the producer of these videos, they're doing a giveaway right now, and it's cool, but it's something you're going to want to get on relatively quickly. Now, you can read all about it in the description directly below the video, but like I said, it's going to end soon, so you're going to want to get on it. All right, with that, let's get back to the video. The case itself, he focuses almost exclusively on the hardware, but through the behavioral characteristics of what ATF did in publishing their final rule, essentially saying it was arbitrary and capricious, okay? The issue that I would like to have seen would be a deeper, more robust analysis on whether or not a particular piece of hardware falls outside the scope of protections of the Second Amendment. There is none of that discussion here. Now, as a result, and even in the decision, he sort of invites legislatures at the state level as well as at the federal level to simply regulate conduct via behavior. So it's not outside the realm of possibility that an anti-gun legislature could sit there and say, okay, fine, you know what, bump stocks in and of themselves are legal, at least at the federal level, but we are going to regulate the rate of fire that someone engages in. So if you're at the range and you're blasting away at your targets and you're shooting at, let's say 1 round every half a second, well, that is in and of itself going to be a violation of law, irrespective of whether or not you have a bump stock or not. Your fingers moving too fast, okay? That, based on what we got here in Cargill, might actually be consistent with this decision. So it is not outside the scope of possibility that we might start seeing those behavioral-based regulations starting to manifest. That does, in fact, concern me. There was no discussion on whether or not common use is in play. That's one of the things that anti-gunners have been arguing for really since Bruin, that the weapons systems like AR-15s and things like that fall outside the realm of common use. It also doesn't preclude a state legislature from creating state laws that would effectively invalidate the use of a bump stock. As we've seen in California, they could say, oh, well, yes, you are more than entitled to have a bump stock on your weapon system. It, however, has to be California compliant, meaning, it doesn't work, right? They could certainly do that. That in and of itself would be presumptively legal, to be quite frank with you, until it's ultimately litigated and determined whether or not the Second Amendment has now been implicated. As I said, in this decision, there was no Second Amendment analysis. So ultimately, it's a win, okay? And we are sort of morally obligated to, celebrate our wins. There's no question about that. But in my opinion, it's a win that could have been broader. Anyways, we'll have to see what ultimately shakes out on that, and whether or not my somewhat nervous predictions end up actually coming to a fruition. In any event, if you have any questions and you'd like to email me, by all means, certainly do so at stephen@artemishq.com. As always, train constantly, train consistently, train repetitively, and train with purpose. Above all else, stay safe.